Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina, and today's topic, Ball is Life, the Alston decision and what it means for sports antitrust law. In June 2021, the Supreme Court held that certain of the NCAA's established restrictions on student-athlete compensation violated Section 1 of the Sherman Act. In this episode of Our Curious Amalgam, we further explore the story behind Alston and what it ultimately means for college athletics and antitrust jurisprudence. Joining me today is my co-host, Jessica Waters. Hi, Jessica.
Hi, Christina.
So what are we talking about today and why is it important?
Well, as you said, a little over a month ago, the Supreme Court issued a landmark decision in Alston v. NCAA. The decision is the culmination of 12 years of litigation, beginning with the 2009 O'Bannon v. NCAA case. As you noted, the Supreme Court struck down the National Collegiate Athletic Association's restrictions on compensation to college athletes in connection with educational expenses as an illegal price-fixing agreement. But this is just the tip of the iceberg. I suspect we're on the precipice of a real sea change in the world of college athletics. And to help me explore this further, I've got a very special guest.
And who is our special guest to walk us through this pivotal case?
Sathya Gosselin. Sathya is a partner in the Washington, D.C. office of Hausfeld LLP, where he advises a diverse array of clients in the areas of antitrust, intellectual property, and sports and entertainment law at both the trial and appellate levels. Sathya graduated from Cornell Law in 2007 and is the vice chair of the Trade, Sports, and Professional Associations Committee of the ABA section of Antitrust Law. While Sathya has represented clients across a range of industries from sports to software, he most recently successfully represented college athletes in their suit against the NCAA in Alston v. NCAA, which is what we're going to talk about today.
Great. I can't imagine a better expert for us to join us today. So Sathya, without further ado, welcome to the program.
Thank you very much. I should offer one slight correction in that I served for many, many years as trial counsel and appellate counsel in the predecessor case to Alston versus NCAA, O'Bannon versus NCAA, which we'll be talking about today. Alston was litigated by another set of plaintiffs and law firms, and my law firm and I nevertheless played a role insofar as we continued to represent our class, submitting amici briefs at various levels. And I can speak to the progression of antitrust litigation in college sports over the course of the last 15 years, if you will.
That's wonderful. Well, Sathya, I have to say I'm really excited to have the opportunity to speak with you today. I don't think I'm alone in saying that this felt like one of the most highly anticipated decisions of this year. I'm personally a newly budding fan of college athletics, and I was rather invested in how this decision came out, so I'm sure this was really exciting for you. I think maybe to get started, it makes sense for you to just give us a better picture of the landscape of college athletics and sports antitrust. What led to the Alston case?
Sure. It's a long story, and some of it is detailed in Justice Gorsuch's opinion for the court, right? The intersection of commercialism and college sports has a 100-year history. For some of us, it's surprising to learn just how long this tale is. When it comes to antitrust challenges, it's really a story of the last 20 years or so. For many, many years in the wake of the Supreme Court's decision in Board of Regents, there was a presumption among many, including, I think, fairly, the sports and antitrust community, that the NCAA enjoyed some form of limited antitrust immunity when it came to its eligibility rules and antitrust attacks. Our firm, Michael Hausfeld in particular, my partner, and I didn't share that view. And when in 2009, Ed O'Bannon, former NCAA and NBA great, approached us to discuss the use of his name, image, and likeness in video games that he had not authorized, we started down a road of an antitrust challenge that would ultimately culminate in a trial victory, upheld on appeal, a separate fees proceeding under the Clayton Act, and I think in many ways spawned some of the subsequent cases, including Alston versus NCAA, and the state legislation that has now given way to an interim policy at the NCAA. I'm presaging many of our conversations today, but if we start at the beginning, we're really talking about an era in the late 80s and 1990s in which the NCAA enjoyed a series of victories suggesting that its eligibility rules, its restrictions on college athletes, were effectively immune from antitrust scrutiny and attack.
That's really interesting. So then came O'Bannon, is that right?
Enter Ed O'Bannon, correct. And Ed O'Bannon was not alone. Ultimately, we represented a class of current and former college athletes in men's Division I football and basketball. And among our class representatives were luminaries such as Oscar Robertson, Bill Russell, certainly Ed, and a group of other very brave individuals who included current college athletes at the time, 20-year-olds, 21-year-olds who were challenging the status quo in college athletics, right? And collectively alleging that the NCAA's restrictions on college athletes, the prohibition on member schools and conferences from paying college athletes anything for the use of their name, image, and likeness in television broadcasts and video games was an antitrust violation.
So where did O'Bannon end up, and how did that then lead to Alston?
So we had 5 years of pretrial proceedings, expansive discovery in O'Bannon, and ultimately had a bench trial in Northern District of California before Judge Wilkin in 2014. My memory is starting to fade. And that was a 3-week-long bench trial and resulted in roughly 100 pages of fact findings and conclusions of law that agreed with our case theory that the NCAA's restrictions on compensation for NIL, I'll use that short form, constituted an antitrust violation and were deserving of a permanent injunction that would enable colleges, universities, conferences to compensate college athletes for the use of their name, image, and likeness up to the real costs of their education, right? That gap between the then prevailing scholarship standard and the various costs that we all know come part and parcel of the college education: books, travel, miscellaneous expenses, all of which are organized under a federal formula. And in real terms, the decision affirmed on appeal and in relevant part resulted in an increase of compensation to college athletes in men's Division I basketball and football that on average looked like $1,000 to $5,000. It depends on location and a number of other criteria per year in perpetuity, which we had estimated at in the ballpark vicinity of $75 to $100 million of additional revenue made available to college athletes from the date of the injunction taking effect moving forward. And so now we're 6 years into that process.
And just so we understand sort of the issue that was handled in your case, it was just focused on the name, image, and likeness practice. I don't know if that's the right way of describing it, but there are a ton of NCAA practices that I think people think may violate the Sherman Act, but the one that you guys were focusing on in your case was what you called the NIL sort of use and the lack of compensation for NIL use.
Correct. So our allegation was that the restraint, right, the industry-wide, NCAA-wide rules and restraints prohibiting member schools from compensating college athletes for the use of their names, images, and likenesses constituted an antitrust violation, was deserving of this permanent injunction. Much like subsequent cases, right, we advanced a relevant market of the college athlete recruiting market, right, in which high school students are recruited to play at these member schools with promises of various benefits. And there can be a range of those benefits. We and our economists argue that those benefits were constrained right, by this restriction embedded in the NCAA rules. Subsequent cases, including Alston, maybe now is a good time to sort of jump to Alston, which started really at the end of O'Bannon and took things a little further, proposing that the NCAA's restrictions on the amount of athletic scholarships was itself a horizontal price fixing agreement.
That's really interesting. So I guess I'm interested in how that case was developed. How did we go from, was it just sort of a natural expansion of the NIL issues to this more broader scope, or were there kind of specific issues that were raised post O'Bannon that Alston tried to tackle?
I think all this is responsive to the needs of college athletes and the input and feedback that we, other lawyers, advocates for college athletes, legislators, were hearing from college athletes throughout this time period, now, let's say 2010 to 2020, which was also a time in which there was a real sea change in public opinion when it came to things like compensating college athletes. And so, well, it's tempting in the context of this particular podcast to talk about the work of antitrust litigators and federal courts in this space. I'd be remiss if I didn't also draw attention to a decades-old college athletics reform community of educators, college administrators, people who have really studied things like graduation rates in Division I college football and basketball, among other sports. So there is a really vibrant body of scholarship and thought when it comes to advocating for college athletes and for reforms more broadly in college athletics. And that includes folks like the Drake Group. It includes the Knight Commission. There are a number of scholars, educators that I've been able to come into community with as a result of this work, who really pioneered a lot of this thinking decades earlier. So I don't want the antitrust lawyers to take too much credit here, even if I do think that we helped bring about some change.
I mean, it's a helpful, it's both helpful to understand the iterative process in which that led to Alston, the litigation that led to Alston, but also the public, I shouldn't say public outcry, but awareness of this as an issue and whether or not that ultimately influenced, how the justices thought about this. You had mentioned earlier that there were a slate of cases in the 80s and 90s in which the NCAA had sort of won a number of victories that seemed to otherwise immunize them. Can you describe briefly what the holdings of those cases held and how you sort of threaded that needle, and maybe how, jumping into Alston, how Alston sort of threaded that needle in view of that precedent?
Yeah, before I do, let me just speak to one little anecdote about a change in public opinion. I have on my office wall, I can't say that I've spent a great deal of time in that office lately, but I have on my office wall a framed cover story from Time magazine in 2013 in the lead up to the O'Bannon trial, in which Time posed the question, is it time to pay college athletes? And had Johnny Manziel on the cover. And that really struck me. I went down to the newsstand right at Farragut North to pick up a physical copy, because it was something of a lightning strike for me to realize that this debate was playing out in national channels and cover stories. So I do think there was a lot of momentum, both as a result of people beginning to question equity in college athletics broadly as audience members, as revenues in college athletics continued to ascend. Justice Gorsuch gets into a lot of this. And also as a result of the immediacy of the O'Bannon litigation, sort of bringing all this to the fore. You had asked a little bit in your question about some of the predecessor cases. And by and large, those were motion to dismiss victories for the NCAA premised on dicta, now confirmed by Justice Gorsuch and the entire Supreme Court, in Board of Regents, suggesting that, at least in the NCAA's version, that the ample latitude it needs to govern college athletics is also tantamount to an antitrust immunity such that it should not be subjected to antitrust scrutiny for its eligibility rules. What was different here? Well, I think one of the key differences in O'Bannon was that we had a judge in Judge Claudia Wilkin who didn't draw on some deep reserves, as she would tell us all at trial, of fandom. That is, college athletics are sort of sacrosanct in this country, right? Those of us who attended big universities and game days, there is a tremendous amount of nostalgia and perhaps even propaganda, if I can use that incendiary term, when it comes to notions of amateurism and the idea that college athletes are apart from professional athletes, and it's the fact of them not being paid, not being compensated for their labors on the field or otherwise, that draws us all to game days and to watch the college football championship. And a great deal of our economic testimony, our industry expert testimony, our own clients' testimony in O'Bannon sought to debunk some of those myths, including the idea that viewership would diminish if college athletes were able to earn incrementally more from the use of their name, image, and likeness. Does that help answer your question, Christina?
That does. And then I guess going sort of to Alston, what was the narrow holding? What was the dicta in that case? And what does that mean for college athletics, for antitrust going forward?
Well, if we start at the trial level, Alston was a considerable victory for the college athletes yet again. It was cabined much in the same way that the relief in O'Bannon was cabined. That is, the ultimate result and the permanent injunction issued enabled colleges and universities to pay, here outside of the name, image, and likeness context, college athletes up to the new educational costs in calendar year, something like 2018. I don't have at my fingertips the date of the injunction issuance in Alston. But that new ceiling of the total costs related to education to attend a Division I university. And so it raised that ceiling again by something like $1,000 to $5,000 typically, which is real money in the pockets of college athletes, and resulted in a series of appeals, first by both sides and then ultimately to the Supreme Court at the NCAA's request. And the NCAA, in the context of its cert petition to the Supreme Court in Alston and its merits briefing, really renewed a lot of the common themes and arguments that we had seen in Alston and that the NCAA revived that we had seen in O'Bannon, that the NCAA revived in Alston. And the Supreme Court was having none of it. The decision is in many respects a blistering one, and now confirms that the NCAA doesn't enjoy any particular special treatment under the antitrust laws, that Board of Regents was always dicta, premised on a series of assumptions, and that there have been significant market changes since 1984, 1986. I sometimes mix up the date of Board of Regents, such that it would be particularly unwise, Justice Gorsuch tells us, to use that dicta as some reason to afford the NCAA special treatment. Justice Kavanaugh took things even further, exercising a separate opinion, concurring and writing to express his view that the NCAA's remaining eligibility rules remain very much subject to antitrust attack and are, in his eyes, quite vulnerable.
And so what do you think the major impact? I mean, you had mentioned, there's already public sentiment. There was already state legislation. Maybe you can speak a little bit to the state legislation that is in the works or has been passed. I mean, is this a meaningful case? How does it change life for athletes in view of some of these legislative changes? And where do you see legislation or the courts going from Alston?
It's a really good question, Christina. There has been, in the wake of the O'Bannon victory and since the inception of the Alston case, a real groundswell of activity in parallel with the federal court proceedings. To begin with, a number of state and federal legislators began looking very closely at this issue. We had the chance to speak with some of them over the course of many years, and felt that this issue, college athlete compensation, and in particular, restrictions on college athlete compensation from outside sources, a field of their universities and colleges, was deserving of attention from the legislatures. And we've seen over the course of the last 4 or 5 years now, the advent of bills, now final legislation in something like 20, nearly a majority of states, 20, 24 states now, have implemented legislation beginning July 1st, 2021, that enables college athletes for the first time, putting to one side the federal antitrust litigation, enables college athletes to benefit from outside endorsements, right? To monetize their name, image, and likeness in conjunction with local barbecues and car dealerships, gyms, all of the things that we alleged in O'Bannon would be sources of revenue in the but-for world, free of these restraints, in which the member schools not just prohibited each other from compensating college athletes for these uses, but also prohibited college athletes from accepting outside sources of revenue for these uses. At the same time, the NCAA had proposed that federal legislation would be the right approach here, and that there needed to be uniformity among the 50 states. At one point in time, the NCAA's president even sent a letter to Governor Gavin Newsom in California, proposing that the then new California legislation, which had yet to take effect, presented a constitutional violation, in particular articulated some dormant commerce clause arguments. I think in the current Congress, and particularly in the wake of the Alston Supreme Court decision, there is nothing approaching consensus among federal legislators about the NCAA, any proposed antitrust immunity that it might seek. And instead, what we're seeing, ironically, is competition of sorts developing among the states, because the Alabamas of the world don't want to be at some competitive disadvantage to the next state school a few states over that might be able to offer increased benefits to college athletes by virtue of recent state legislation.
So just to unpack that a little. So if I'm an athlete in California, as a result of the Alston decision, the college can now pay me up to the scholarship amount or whatever that cap is. And in addition, because of state legislation, I can get outside endorsements from the local restaurant, and presumably even from national, marketers or brands. But if I'm in Alabama, where they don't have the legislation, as you're saying, then do I still have access to national brands and I just lose local revenue, or am I prohibited from all outside endorsements and payments?
Yeah, and I'm just using Alabama as an example. Candidly, I don't have in front of me my
maybe Alabama may not. Yeah, who knows?
my trusty spreadsheet updated by a paralegal that tracks the state. I'm being serious. State legislation in every state. The answer is even more diverse, if you will, in that things are moving very, very quickly. I think the easiest way to think about it is that there are, as a result of the last decade, and in particular as a result of the last month, a variety of new benefits available to college athletes, right? Whether it's by virtue of increased scholarships and name, image, and likeness payments coming from the schools themselves, right? Or the ability to monetize their name, image, and likeness from outside sources, right? The NCAA is very much embattled at this point in time and is talking about revamping its constitution altogether. And one of the other pieces to all of this that has been lurking throughout the last decade, right, is some of the conference realignment that is occurring and the growing power among certain member schools and conferences that calls into question the need for the NCAA to play its current role, right? The NCAA could have a role as small as officiating games and generating rules for the actual games played, or it could play as expansive a role as it currently does. And as we see, for example, University of Texas and Oklahoma moving to the SEC and some really seismic shifts in some of the balance of power among the conferences and the advent of conference-specific streaming services and channels available and conference-specific revenue streams, there are some very significant conversations being had, I think, at every level of higher education and college athletics about the role of the NCAA moving forward over the next 20 years.
Something I'm kind of interested in, Sathya, and I'd be interested to get your opinion on is, what do you think is to become of, say, collective bargaining regimes? Do you think that there's a possibility of college athletes banding together to start pushing towards a players' union?
It's a really good question. I think that is one of really three pillars here to further reforms, maybe four, if we talk about some of the organic processes that are occurring within the NCAA and among the member schools. But as I see it, there's still work to be done by federal courts and antitrust litigators when it comes to advocating for college athletes. And at the same time, we're seeing coalitions, federations of current and former college athletes banding together, seeking a collective voice on these issues. And whether that's in the form of a union with a capital U or some other type of negotiating unit remains to be seen. But I've even just watched over the course of the last month, just really interesting conversations among college athletes that are playing out in real time on social media and forming websites, and just college athletes in dialogue with other college athletes about fairness and equity. Additionally, I think we'll continue to see legislators taking a look at this, whether it's the NCAA hoping still for some form of antitrust immunity, which seems unlikely at this point in time, but is nevertheless referenced, right, by Justice Gorsuch, or state legislators who are seeing a tide of change in other states and realizing that to remain competitive for the premier high school athletes, right, to recruit those individuals, change will need to come to those states as well.
Great. Well, Sathya, a very dynamic, changing, evolving space. Lots of actors, federal courts, public policy, and state legislators, and perhaps the NCAA itself. I think it's an interesting time to be a potential college athlete as they navigate, admissions and the like. And I'm sure we could talk much more about this, but in the interest of time, we're going to pivot to a more personal section of our podcast. We like to get to know all of our guests a little bit more. So first, could you please tell us something about yourself that we wouldn't know about you if we only knew you professionally?
Gosh, it's tempting to go straight to some hobbies, right? I'm an avid fly fisherman. I'm a former DJ of house and techno music, which is
Nice.
a resurgence in COVID with my kids here. And I love to ride my bike. I'm a cycling addict, particularly here in Washington, D.C. I'll note, too, the intersection of the professional and personal. My work on this case in particular, and at the intersection of sports and antitrust, has made me considerably more popular at cocktail parties when talking about my profession, at least at a time when we still did those things. So my wife was happy that I wasn't just droning on about econometrics alone.
Yeah, I mean, you mentioned fly fishing and cycling, and I'm like, pretty sure those aren't college sports, maybe. But do you have a favorite college sport?
Well, it's really interesting. O'Bannon featured a whole slew of lawyers who are probably at best middling fans, Michael Hausfeld, my partner and our namesake, cops regularly to knowing very little about college athletics, right? Or athletics full stop. I went to Vassar College, which didn't have a football team, in Poughkeepsie, New York. Years later, I would live in Austin, Texas, and get a little bit of a taste for, big time college football. So I'll go with the Texas Longhorns. But one of the things that our clients seem to value, and this is true at the professional sports level, is that we are advocates first and foremost, and that we're not attempting to master their sports bios or impress them that we know every last piece of minutia as fans, right? They get that all the time. They're coming to us for very specific and guided advice, counsel. So in some ways,
earlier point, you don't have the fandom, right? So you're able to kind of look at everything objectively. So that's great. Yeah. Maybe this leads into our second question, but advice that you have for young lawyers or professionals who are interested in doing what you do.
This actually is a nice tie-in to the ABA section of Antitrust, because I regularly tell people who are in law school or fresh out of law school that the section is replete with opportunities for those folks to volunteer to write case summaries for our various newsletters that are now taking on a digital form, to assist in our various publications, to help generate programming ideas and blog posts. And I think often coming out of law school, people assume that the only publication that one could include properly on a CV is a published law review article. The reality is, for those of us who have been practicing for a long time, that there's real value in something shorter and more timely. And that's not to disparage in any way the great law review articles that are out there, but I encourage young lawyers not to sell themselves short, that this is sort of all or nothing. Additionally, I really look for people who have a demonstrated and enduring interest in antitrust, in litigation, in the types of industries that we often find ourselves toiling in, our clients. And so those two things sort of feed off of each other, right? If you have been steadily publishing and working with an ABA committee for the last 18 months on, say, the topic that we've discussed today, well, then you've already shown me, before you've even walked in the door, the ways in which you have this sort of demonstrated commitment to the work that we do. I should add, too, that I'm looking for something broader than just the O'Bannon litigation in college sports. Sometimes we receive cover letters and resumes from folks who assume that's the entirety of our practice. And I assure our listeners that it's broader.
Not just a sports law shop. Well, I echo that. I can't recall the last time I read a law review article front to back, but I have read the Antitrust Source and the Antitrust Magazine and the various ABA publications. So now moving to our final segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
Sathya, can I ask you to pick a number 1 through 25?
18.
18. What is an accomplishment you are most proud of? And what is something on your bucket list that you'd like to achieve?
At the risk of going with an easy answer, right? The O'Bannon victory really does tower for me. I was a fairly young, inexperienced lawyer when I first started on this case, and was able to see it through and cross-examine witnesses at trial, play a pivotal role in the appellate phase of all of this, and spearhead a second subsequent satellite litigation, not by our choice, that lasted for 3 years on the fee petition under the Clayton Act. And so to be able to affect this sort of lasting change through the use of the antitrust laws for college athletes nationwide, and also demonstrate our worth as a series of law firms to the federal court and receive payment for that, which was all on a pure contingency basis, was deeply satisfying, and still ranks among sort of my proudest achievements in this space. What is on my bucket list? This isn't fully formed yet. It's not fully baked, but I think coming at this point in the pandemic, we are all, I think, sort of juggling personal and professional responsibilities and working from home. And I'm hopeful that in a world in which we can all be together again, but still retain some of the benefits of all of this sort of remote working, that I'm able to do something really extraordinary with my family and be able to travel, but also, with all these technology tools, remain engaged with my clients and my casework. And so I'd like to think that this creates sort of opportunities for, I don't know, being on a mountaintop somewhere and still being an antitrust litigator and attending my children too. I mean, I say all of that sincerely, but also recognizing just how challenging and painful and difficult this entire episode has been for so many people.
Well, here we are recording a podcast virtually. Next time, Sathya, you're on, you will be on top of a mountaintop, and we will be happy to record a podcast then. Well, Sathya, again, thank you for your time today. This has been incredibly interesting and educational. And to all of our listeners, thanks for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.